Should we give another minute or two for the other committee members? Or do we know
Um,
that everybody who's
I
going to
know
be
that
here is
Sam
here?
is not joining. I did hear that Dr. Espinosa is, and I haven't heard from Betha Schnell. So let me check with Macaulay. I know she's doing a reach out.
Hi, everyone. I am doing a reach out. I have not got confirmation yet from Betha or Dr. E, but I will continue to try to reach out to them.
Okay.
Perfect.
And we can go ahead and, establish quorum and go at least through the minutes before any like real decisions are made. So at that point, if you want to start this up, that gives them time to still join before we get into like substantive talk.
Okay, sounds good. All right, with that in mind, I think we're going to call this meeting to order. I am the vice chair of the committee, Edward Ray, and I'm standing in for Samantha Gambles-Farr, who cannot make it today. So with the meeting called to order here, we'll start out with a roll call. And we understand that there may be some more committee members joining later. So Samantha Gambles-Farr, she is not present, correct? Okay. Edward Ray, that's me, I'm here. Dr. Andrea Espinosa?
Not in attendance yet.
Not here. Jan Griffin, nurse practitioner?
Present.
All right. Kevin Maxwell, PhD. Dr. Maxwell, he's present. Sally Pham, nurse practitioner, present. And Betha Schnell.
Not on as of yet.
Okay, very good. Okay, so we have a quorum. Next, we're going to ask our board moderator to review the instructions for our teleconference.
Good afternoon. This is the BRN moderator. I will be moderating the meeting. To facilitate public comment, we will be utilizing the WebEx question and answer feature. When the committee reaches a point in the agenda at which public comment is appropriate, the question and answer feature will be turned on, and members of the public can indicate that they would like to make a comment by inserting the phrase, "I would like to make a comment," in the question box, which is typically in the lower right of your screen. We will also query our physical location, our in-person location here in Sacramento, BRN's HQ. I will then call on the individual and unmute their microphone. The individual will have 2 minutes to make their comments. I will not give a warning as your time approaches. I will mute your microphone and will announce that your time has exceeded the time allotted. I will then proceed to the next member of the public who has a comment. Please note that the question and answer feature is being used only as a means for members of the public to represent that they would like to make a verbal comment. When your turn comes, you will be prompted to unmute. If your question can be answered, the committee will respond accordingly. When making your comment, speak about anything you believe is important for the members to know. Remember, committee members cannot address any item not on the agenda. Items not on the agenda at that moment, items that you would like to add to a future meeting, or items that will be discussed later on the agenda will be discussed at their correct times during the meeting. I will provide a brief reminder of this approach at the start of each public comment item. Finally, when committee members or BRN staff are not speaking, I would like to remind them to mute their microphone. If I detect background noise during the meeting as a result of unmuted microphones, I will mute your microphones automatically.
All right, thank you, moderator.
Board moderator, Betha Schnell and Dr. Espinosa are both on. Can you elevate them both, please?
Okay, we'll mark them as present.
Wonderful. Yes, if you want to do roll call real quick and include both Betha and Andrea, then we can also do mic and video check on them.
Did you want me to repeat the roll call or?
Yes, please.
Okay, let's go ahead and do that.
Well, not the ones you already called, but just Dr. Espinosa and Betha.
Gotcha. Dr. Andrea Espinosa?
Present.
Thank you. And Betha Schnell? She might be having some mic issues.
Yeah, I can see Betha. I can't hear her. Betha, are you able to see us and respond?
She is muted. Has she been elevated to a panelist?
She is, or she would not be on screen.
She is muted.
I'm not sure if she's able to hear us. Macaulay,
Oh.
can you also reach out to see if she could hear us?
Betha, can
Please.
you hear us?
Yes, I can hear you. Can you hear me?
There's,
Perfect.
there's,
Yes.
Yeah, if you could just confirm that you're present.
Here. Yep.
All right, very good. So we're amending our roll call. All right.
Perfect.
So next agenda item is public comment for items that are not on the agenda and potential items for future agendas. Board moderator?
we will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." NP watching would like to make a comment. 1 second, please.
Thank you for letting me make a comment. I think that it's important to note that I think we should add onto a future agenda that there should be a more robust education component to educating nurses the difference between intervention and probation up front, because I think it is important to note that only one advanced practice nurse has been reinstated looking at the data from 2018 to 2024. This is an important component of advanced practice. When you look at all of the data concerning enforcement, because I don't know that people are getting the appropriate education up front when they're trying to pick between intervention and probation. And you can see that in the comments, the public comments that are misdirected. And I am one of those commenters. I keep commenting. And I myself was getting all of the education from my lawyer, because I knew that if I called the BRN or Maximus, that I would have my personal information collected. And my case went on for 5 years, and I was not convicted. But all of my information is still publicly up there on the web, and I was not convicted of the crime. But I have an accusation. Thank you.
Thank you for your comment. Committee Chair Ray, there are no other public requests for comment on the WebEx. We have no in-person representation in our HQ website room. Sorry, HQ meeting room. Would you like me to close this window?
Yes, moderator, thank you. Okay, so next agenda item, we're going to review and vote on our previous meeting's minutes. Do we have any comments from the committee on any concerns about inaccuracies?
This is Dr. Espinoza. I move that we approve the minutes as
Okay, we
written.
have a motion. Is there a second? Okay, and no other comments?
I'll second. Jan Griffin seconds.
Okay, so I think the next step is to open this for public comment before we take a vote. Board moderator, could you open this agenda item for public comment?
We'll be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember you will have 2 minutes to make your comments. I will not give a reminder as time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Sharon Bogan would like to make a comment. 1 second, please.
Hello, thank you. Sharon Vogan from Oakland. I just wanted to note on page 9 of the packet where the minutes list my name, it says Sharon Logan with an L. And so if you just correct that to Sharon Vogan with a V. Thank you.
Thank you for that comment. Can we amend the minutes?
Yes, we can.
Thank you for your comment.
Any other public comments?
Committee Chair Ray, there are no other public requests for comments on the WebEx. We have no in-person representation in our office or in our HQ office. I will get that right eventually, sorry. Would you like me to close this window?
Yes, please, moderator. Okay, and in
And
light of the fact that the
person
minutes are
who-
being amended,
Yeah.
sorry, did someone?
I was just gonna let you know, the person who made the motion and the second will need to make an updated motion and a second to include that amendment.
I move that we amend the minutes from our last meeting as brought up today.
And move to accept those minutes, is that
I
correct?
move to accept those minutes.
Okay, and do we have a
So I'll
second?
be,
Second,
I'll be,
Jan
I'll have to
Griffin.
make the motion just slightly clearer. On page 8 of the meeting minutes and the posted materials, the second person to speak is Sharon Logan, and they have asked that it be Sharon Vogan. And so, Dr. Andrea Espinosa, are you okay with us amending that and amending your motion to reflect that?
I move that we reflect that to the detail requested.
Thank you. And
I'll
then,
second that, Jan Griffin.
thank you, Jan. Appreciate it. And now you can do the roll call vote, Dr. Ray.
Okay, let's vote on this motion to accept the minutes as amended. We're gonna do this as a roll call. Samantha Gambles Farr is not present. Edward Ray, I vote yes. Dr. Andrea Espinosa,
Yes.
Jan Johnson Griffin,
Yeah, yes.
Dr. Kevin Maxwell,
Yes.
Sally Pham,
Yes.
and Betha Schnell.
Yes.
Okay, this motion is accepted. Let's move on to the next agenda item. Okay, so we have an information only report from EO Melby. Please go ahead.
Thank you. And this is going to be short and sweet because I'm actually going to defer most of the report to the agenda item 7.0 with the discussion around SB 1451. So AB 890, we're continuing in a holding pattern on the implementation of that. There has been a lot of conversation about retired and legacy certifications and various things around that. And so I am going to defer to agenda item 7.0 to do further discussion because that was addressed in a bill that was chaptered yesterday, I believe, by the governor. And so if you guys have any specific questions to AB 890 not pertaining to SB 1451, then I'm happy to entertain those here today. But because of agenda item 7, there's not a whole lot on this one.
Okay, any comments from the committee? And my understanding is for information only, is that not open to public comment?
It's open to public comment, but no motion needs to be made. And it looked like Dr. Espinosa was trying to say something. I'm not sure if
Yes.
you're able.
I'm sorry.
Okay.
Dr. Espinosa.
Just wanted, so if we have some comments or want some clarification for the next, when it comes back, do we let you know or put it in writing, or what do you recommend, or what do I need?
When it comes back, so I'll need some further clarification on that. Are you referencing SB 1451 or are you
Yes.
referencing? We will have more discussion on 7.0 and we can get deeper into that at that point. So if you're willing to hold your question till then we can dive into that more.
Gotcha. So that'll
Thank
save some time for this meeting. Any other thoughts or comments from the committee? Okay, seeing none. Board moderator, we open this agenda item for public comment.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Committee Chair Ray, there are no public requests for comments on the WebEx. We have no in-person representation in BRN HQ. Would you like me to close this window?
Please, thank you. Okay. Next agenda item, we're going to discuss and possibly have a motion regarding meeting dates for 2025. And I believe on page 18 of the meeting materials, there are a list of dates for next year.
Yeah, so the two that we're asking you guys to consider are March 18th and September 23rd. The Nurse Midwife Advisory Committee was able to accept those today, and we'd like to hold you guys on the same day, but if it's not possible, we can always make some alterations. So if you guys can take a look at your calendars and make sure that you don't have a vacation planned or procedure or birthdays that you'll be celebrating that you won't be able to attend, look at those two dates, let us know. And if you're able to do it, just make a motion to accept. If you're not, propose a new date that might work best.
All right, so committee members, we want to make a motion on this today. We'll give you a few minutes to look at your schedules.
The next meeting would be, just for clarification, would be when? A proposal for March 18th or?
March 18th.
March
2025.
18th would be the next one, and then the end of the year is September 23rd. So that's your spring and fall dates.
September 23rd is Rosh Hashanah, just for anyone who might be observing that holiday. So I guess we can either just let people comment, or we can take a roll call vote.
So we'll
and
need
like
a
every other-
motion first. So if there's anybody, are you guys good with the dates? It
I
looks
don't
like
have any
not from
concern
everybody.
if anyone else does. Yeah.
Yeah, so then do a motion to accept in a second.
Do I hear a motion?
I motion, this is Dr. Espinosa, I motion that we accept the advisory committee dates for March 18th of 25 and September 23rd of 2025.
Okay, do we have a second? All right, Beth Schnell gave a second. I guess we have to, like all our other agenda items, have to open this up for public comment. So board moderator, if you could go ahead and do that.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for a comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. We'll mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Sharon Bogan would like to make a comment. 1 second, please.
Hello, thank you, Sharon Vogan from Oakland. I see later on the agenda, there's a discussion about subcommittees. So I don't know if it's here or then. But I'm just wondering, with 104 discussion coming up and everything, and there's a lot to discuss, and there'll probably be a lot to work out. I'm wondering if this committee could meet more than twice in the year, just because I think it would make for a really long meeting if you only had two. So I was just wondering if that could happen, or if you're trying to address that with subcommittees. And if the subcommittee is the solution, then I think nurse practitioner should be on the subcommittee. But my main question is asking if you could meet more than twice a year with so much to discuss.
We do have an option to do a special meeting if needed. Right now, it has not been decided that a special meeting is needed. A lot of the work is going to be done in subcommittees and by board staff. The subcommittee makeup as it is has in the committees that have a physician in, it is not two physicians in one committee. It is a physician and a nurse practitioner. And so there are subcommittees that are both nurse practitioner based. And then there are subcommittees that have a physician with a nurse practitioner. And those have been effective and have not had complaints raised from them in the historically. So I think they're okay to continue as is.
Okay, great. Thank you for that answer. And I was just wondering then, how is it decided if another meeting would be needed?
So once we have the discussion coming up in 7.0, where we talk about the bill and what needs to be done to implement that, there will be discussion then to follow in the subcommittees on assignment of those tasks. If the subcommittees believe that they can get that done in a reasonable amount of time without calling an additional meeting of this committee, then we will move forward as that. If it is decided in the subcommittees that they do not believe that they can do it without an additional meeting, or at any point in between meetings, if we are brought to our attention that another meeting needs to be done, then we can look at scheduling it at that point. The purpose of the subcommittees, which is, I believe, agenda item 8.0, is to allow for work to be done. Sorry, it's not 8.0, it's 9.0. I'm completely off. It's here someplace.
Okay, no, thank you. Thanks for answering
Thank
the
you.
question.
It allows for a lot of work to be done outside of committees, and I'm sorry I wasn't able to pull the number up right on time.
I know, yeah, no
And
worries.
so they're able to meet with subject matter experts. They're able to meet with anybody outside of this advisory committee. And a lot of times it's incredibly helpful. And so they may go to our regulatory counsel, to myself, to our legal counsel, to my chief of legislation, Marissa, who board moderator, if you're listening, please elevate for the next agenda item. And really have those conversations. And if there are regulation updates that need to be done, those regulations can be written, and there's a lot of deep dive into those when that occurs. And then by March, we can have a lot done. And by March, we come in and we report out everything that has been done and accomplished in the subcommittee. And the advisory committee here makes a motion to accept it and move that to the board. And so truly utilizing the subcommittees in the fashion that they are developed, which this group has done historically, is a fantastic expediter for any of these. Because when you get a publicly noticed meeting and you have to have all these discussions with everybody involved and stakeholders and such, they can go on for 8 hours easily. And so this allows for many more hours outside of 8 hours to get that done, so that by the time we bring them to the committee here, if we do need to have additional information, additional conversations, then in March, they can say we need a stakeholders meeting, and we can call a stakeholders meeting to discuss the language that was already developed, right? Instead of developing the language and then having multiple meetings down. So
Right.
everybody here in the advisory committee, as well as the public, will get a chance to comment on every item that each subcommittee produces. It is not done in a vacuum and kept away. So we will accommodate for that. And as we move along, if a new meeting needs to be added, we can do that.
Great. Thank you so much. Appreciate it.
Welcome.
I would just add to that comment, and in the same vein, on behalf of the committee, really want to thank EO Melby and the rest of the BRN staff because they've really done a great job at recognizing when there's issues potentially coming up that are going to affect our work and, get this committee involved very quickly. And I have no doubt that if there's, any issues that come up, whether it's with SB 1451 or anything else, that it's going to get addressed pretty quickly and brought to the public attention. So thank you for that.
Welcome.
Thank you.
Board
Moderator,
moderator,
do you
is
have
there
any
any
other-
more public comment?
Thank you for your comment. Committee Chair Ray, there are no other public requests for comments on the WebEx. We have no in-person representation in BRN HQ. Would you like me to close this window?
Yes, and thank you, moderator. Okay, with that in mind, we'll take a roll call vote on the motion to accept these meeting dates. Just pull up my list here. Samantha Gambles Farr is not present. Edward Ray, I vote yes. Dr. Espinosa,
Yes.
Jan Griffin,
Yes.
Dr. Kevin Maxwell,
Yes.
Sally Pham,
Yes.
and Betha Schnell.
Yes.
Okay, this motion passes. So the meeting dates are voted on and confirmed. Okay, next agenda item. And again, this is another information only report. I guess we're going to do a deeper dive here into Senate Bill 1451. Please, EO Melby, go for it here. Tell us what we need to know.
Thank you. So Senate Bill 1451 was a committee bill. It is typically used by Department of Consumer Affairs, and each one of the boards and bureaus underneath them bring forth existing law that might need a small, non-substantial kind of update. Additionally, this is where other information can be added by the committee chair, and Marissa, feel free to jump in here at any point that I'm misspeaking. This bill here did see two updates that are important to come in front of NPAC, and that was on specifically section 7, and then again section 9 through 12. And so if you're in the materials packet and you click on the link, it'll take you to this. So I'm going to screen share and pull up the bill. Now understand this bill was chaptered and signed, so there is no further edits that can be made to this, and it is law as it is shown today. And so I will scroll down to section number 7, sorry. And so section number 7 is has been seen as a fairly controversial section, and that is updating Business Professions Code 2054. And 2054 is a business professions code that is part of the Medical Board's Practice Act, and not our Nurses Practice Act, but it does affect more than the Medical Board. And so what this one here is updating is the use of the term doctor. And so previously, the use of the term doctor was forbidden to many, and this has actually expanded that law so that a person here says that, I'm going to try to highlight it here really quick, just so everybody can see this right here. It does expand it. And so basically it says that any person who uses in or uses a sign, business card, letterhead, or advertising the word doctor or physician, the prefix doctor, MD, DO, or any other terms or letters indicating or implying that the person is a physician or surgeon, physician, surgeon, or practitioner under the terms of this or any other law, or that the person is entitled to practice hereunder, or who represents them holding out as a physician or surgeon. This is where we have had our advanced practice RNs very upset that they cannot use the term doctor. And so here they did update it and said, or implying that a person is a physician, surgeon practice in a healthcare setting. That would lead a reasonable patient to determine that the person is a licensed MD or DO. So that's really where we honed in our board meeting. And we made a position where we recommended that they update this language. There was concern brought forth by the advanced practice board member who is a nurse anesthetist and an educator. And as an educator, she is able to, in an academic setting, be called Dr. Patel. And that is a very common recognition given to people within academia. The problem that she felt was of biggest concern is when she follows those students into a healthcare setting. And when in a healthcare setting, her students may call her, as what they're used to, Dr. Patel. And if they called her Dr. Patel in a healthcare setting, it could be interpreted that a reasonable patient could determine that this person is an MD or a DO instead of a nurse anesthetist. And so that was seen as problematic by our board. And therefore, they wanted that to be altered in some way. It did not get altered, and this is the language that we're with. And so the key is that when you are an advanced practice RN, if you do have the letters doctor within your title, that you make it very clear that you are a nurse practitioner and not a physician. And that in a healthcare setting, that would be the greatest risk if you plan to continue to use the term doctor associated with your name and title. I'm going to stop screen sharing and allow for discussion on this section before we go to another section. And Marissa, if I missed anything on this particular part, if you can update, that'd be fantastic. If not, we'll open it up to further discussion.
Just to quickly clarify, there's typically 2 bills, or at least one every year. This isn't the non-substantive change bill.
Oh,
the Senate Business Professions and Economic Development Committee will almost always have a code cleanup bill that they hold every year. And that's where you have like grammar fixes, citation updates, nothing that is policy substantive. And so that usually is kind of an underlying bill. And we have some kind of cleanup stuff in that. They also have the option of doing an omnibus policy cleanup bill, and that's what this bill is. So it does actual policy changes for a variety of different boards, making it definitely a much more complex and complicated one. So I just wanted to kind of discern between the two. The code cleanup bill was, I believe, SB 1526, and then the policy omnibus bill is SB 1451. That was it.
Yeah, thank you for that clarification. I have a comment and sort of a question, I guess. And EOMLB, I don't know if you can answer this or if this is a question for council, but reading the letter of the law here in section 7, it says that any person who uses in a sign, business card, letterhead, or advertisement the word doctor. So I would say that in day-to-day conversation, that's not really covered under this law. Meaning it's only if they say to somebody, I'm Dr. So-and-so, as opposed to somebody calling them a doctor, or, whether it's in a healthcare setting or an educational setting. At least the way it reads here, it's only if you're advertising or putting on your official letterhead, Dr. Smith, as opposed to, your credentials, which are going to show that you are, whether it's you have a nursing doctorate or a medical doctorate. Does that make sense the way I'm asking it? And is there some other law that we're not seeing here that takes it a step further than what we're hearing about?
Harry is on the call, and he is our stand-in legal counsel. It looks like he's raised up to read that language a little more clearly and probably opine on it. Some of the feedback that we received as Harry's kind of looking at that language, was that advertising doesn't necessarily mean like getting media and billboards and stuff like that, that it just, as they present themselves, could be advertising. And so if they're not redirecting when that's said in front of a patient who could reasonably determine that they may be a physician or surgeon, that could be seen as problematic as well. But I will let Harry further explain if he saw something different at that point.
Oh, thanks for throwing something cryptic at me.
Any day, anytime.
My reading is, clearly the advertising is unambiguous. So if you're advertising and you're using the term doctor, it's problematic unless you qualify it with the other titles that you also hold. And it should be clear, that you're not a medical doctor. So that I don't have a problem with. The problem is going to be, again, in a informal setting when someone is referred to as a doctor, or let's make it even more precise, when someone is wearing a name tag, which people normally wear when they're in a hospital setting or in a patient setting, I would assume. I don't know if that's the case, but I'm assuming, based on my personal experience, that certainly in a hospital setting, if the term doctor is not qualified with the other titles, that is going to be problematic. And so I think that's going to be the distinction. It has to be for the average consumer who looks at the person standing in front of him in let's call it a white lab coat or whatever you want to call it, and he's referred to as doctor, and by itself, that is going to be a problem on a case-by-case basis. And so what is the answer? I think the answer is going to be the obligation is going to be upon the individual themselves to clarify when they introduce themselves that they are not a medical doctor. So that has to be the way that this could be approached. So I don't know if that makes any sense, but that's my reading of it. When it comes to advertising, clearly it has to be specifically indicated that doctor is not a medical doctor and that there are other titles that the individual holds that identify the education and so on of that individual. Name tags, the same should be true also. So it should be unambiguous that the person is not a medical doctor, that they have other titles, and the obligation would fall upon the individual to clarify that they are not a medical doctor. That's my my best read on it at this point. I don't know if that makes any sense, but that would be the approach that would make most sense to me.
Thank you.
Any comments from anyone?
Yeah. Dr. Espinosa?
Yeah, I had a comment. Can you hear me?
Yes, can hear you.
Okay. My comment is that, I'm getting an echo. I'm sorry. Hold on. Okay, my comment is that I thought it was taken care of in 890 when it was very clear that you could not use to imply I'm Dr. So-and-so, because that could be confused with the physician and surgeon. So why did they add this? It seems like this is supporting that further.
Anyone have any insight on that one?
And it looks like Marissa wants to speak too, so I'll just kind of address really quick. So in our Nurse Practice Act, which again is a separate section, right? So this is part of the Medical Practice Act, not the Nurse Practice Act. In our Nurse Practice Act, with our regulations for nurse practitioners, as well as in the statutory language for nurse midwives, there are sections that state that we have to identify ourselves as a nurse midwife or a nurse practitioner And nurse midwives go even further than a nurse practitioner, and they add it to the patient's chart and have a signature from the patient as well, saying that they know that it is a nurse midwife that is caring for them. We do not have language that address the clinical nurse specialist or the nurse anesthetist. And those, the nurse anesthetist has a more independent practice. A clinical nurse specialist at some point in the future may end up with an independent practice here as well. They currently do not have that. So we would need to update those sections to reflect that notice. That what that still doesn't reflect is we do, and as Harry brought up, there's a separate business professions code that actually specifies the font, the type of the name badge, and that a name badge is required at every employer of the licensee. And that's more of a DCA-wide business professions code for the licensing boards underneath them. And so that there does not have any kind of clear that you have to say Dr. Kevin Maxwell, nurse practitioner, right? Because he's obviously affected by this, having a PhD and a nurse practitioner license here. Then we would also take a look at not just the patient. And so we have specific language around identifying your clinic. We have specific language around notifying the patient. This goes further and says where any reasonable person could identify them. And so it may not be your patient, it may be a member of the public. But this actually, the update to this law made it more accommodating to our providers that have a PhD or a DNP. It did not make it more limiting to them. The previous language forbid the use of the term doctor at all in that form. And so Marissa, if you could update or add.
Yeah, I was just gonna state that in 890, you're correct. It has a provision around a nurse practitioner informing new patients that a nurse practitioner is not a physician surgeon. But I would just highlight that BPC 2054 is speaking to kind of cross-board licensees. That from our perspective, obviously that's all APRNs, but also we are not the only board that could potentially have licensees utilizing that terminology. And up until now, when there has been concerns or issues around usage of that title, I think that is since that is within the medical board's purview, that has been the section that has been quoted as the enforcement piece. So I think that is more of a broad brush across any board licensees that could potentially use that terminology, whereas AB 890 is a specific, you're speaking to a new patient as a nurse practitioner. It's a much more limited circumstance.
And some of the healing art boards that are underneath DCA are your naturopathic doctor. It's also your chiropractic doctor as well. And so those terms are utilized in their practice also.
You know, it's my 2 cents here. I think it's a little unfortunate that we have such ambiguity in our language, that we have these terms that can mean many different things, and how they can people can sort of consider them as a way to appropriate you know, stolen valor or whatever you want to call it. But I would say it's unfortunate because the word doctor is actually more appropriately given to someone who's a teacher, because it comes from the Latin word to teach, docere. So, you know, we should be calling doctors physicians and call, you know, people with PhDs doctor. I think that would be the proper way to do it. And, you know, they don't have this problem in the United Kingdom. This is a very American problem because, for example, surgeons actually prefer to be called Mr. and Miss. They consider the word doctor to be kind of derogatory. It means you're, you know, no offense, Dr. Espinosa, but it means you're a primary care physician rather than someone who's done postgraduate training in another specialty. So they actually prefer to be called Mr. So this is something very unique to the American English language, I think, that we're struggling with here. And I think it's been taken a little too far. That's kind of my opinion. Obviously, there's not much we can do about the laws here, and I don't think there's anything wrong with, out of respect, calling someone who's a PhD doctor. I think the key here that I'm taking away from this legislation is really that, you know, they don't want people advertising in a way that might be deceptive, and, you know, I don't see that as being a major issue that we're dealing with on a day-to-day basis. But to be continued, right? And we sort of see what sort of complaints come before the board, you know, when 103s and 104s are out there. So
Definitely. And so moving on to the next section of just consideration for further discussion is going to be section, starting on section 9. And I'm going to screen share again so that the language is up in front. And section 9, you guys will recognize, I am sure, as the previous AB 890 language, where it comes in and starts talking about, you know, forming this committee for 101, and then doing the transition to practice, and then going into your 103, and then ultimately down through 11, which is 104. And so at this point, if Marissa, if you're ready, I would love for you to kind of take over and give kind of the same rundown that we gave our board members when they took a vote on this, if that's something that you're prepared to do.
Yeah, I can kind of high level go through some of the main changes, and then we can dig in more if there's any questions. So first, starting with the transition to practice, that is obviously the 4,600 hours that is currently required to go from an NP to what we refer to as a 103 NP. There were some changes made to that to make it a little less kind of restrictive. Two of the main changes was that the law prohibits the clinical experience from being limited to a single category. So currently in our regs, we have a requirement that the category they practice those 4,600 hours in has to align with their national certification, and it has to just be in that area. This passage of this law would remove that. It would allow for those 4,600 hours to be in a variety of different content areas. Our regulations also currently require the attesting provider, whether that's another NP or a physician and surgeon, to also specialize in that same content area. And this law would also remove that requirement. So it would make it a little bit easier for NPs to meet that 4,600 hour requirement by stating that their experience can't be limited to a single category, and their attester doesn't have to specialize in the same category that they are specializing in. So that was a pretty big change. There were some clarifying pieces around just the attester themselves. Clarifying the attester is not required to verify the competence of the NP. That was something that was already in practice with us, but I think they wanted to make it really, really clear because there was some apprehensions that have been expressed around when they are attesting, you know, what are they attesting to? So I think the law wanted to make it really, really clear that the only thing they're attesting to is to the completion of those hours. They're not attesting to anything further in regards to competence. The bill also clarifies the attester is not going to be liable for any kind of civil damage or administrative action or penalty just because they attested. Another kind of concern that I think had been raised, they want to make it really, really clear that the attesters are not going to be on the hook for any type of punishment. The only potential caveat to that is if they attest fraudulently. So if they knowingly attest to hours that they know weren't completed, then there could be potentially some sanctions there, but just the act of attesting to hours they think were in good faith completed, there would be no penalties. So that's just the transition to practice component. Are there any questions on that piece? Yes, Dr. Espinoza.
It's Dr. Espinoza. Or somebody, I'm sorry.
go ahead, Dr. Espinoza.
Okay, I'm going to go back to this a little bit because the attesting, the transition to practice and that attestation, it's not for competency, but then any physician can attest to whatever, and that person may not have any competency. Well, maybe we don't need to deal with that competency issue, but in the long run, if he or she becomes in the 103, it seems that at that point, it's not okay to just attest to, oh yeah, they did their hours, particularly since we're looking for primary care providers. That was the intent of the law, not to make orthopedics, not to make specialized endocrinologists, not It's all in that certification. And an orthopedic technically cannot certify primary care, only one little section. But if you're attesting, I understand that it's just attesting to the hours. But in terms of 103, it seems that you have to look at competency, especially that's where that issue comes by in on what do you call the collegial discussions with other team members and mentors. So we basically, what I can see right now is that part is put to the side because we don't know how to do that. But I think we're going in a dangerous path if we only say anybody can attest. And we may have already said that in our regulations, but I think, I think physicians have something to say if they're attesting. And anybody can sue, correct? It doesn't matter what they want to sue. But what I'm concerned is that any physician who is not a specialty in primary care actually attest to hours. I'm okay for the transition of practice, but I'm a little concerned about where we're going if we do that for the 103.
I'll try to provide a little reassurance, hopefully. Our regulations were much more prescriptive. And so now that this is in law, statute will always supersede regulations. So we will have to alter our regulations. I think they will be edited where we will remove the specific sections that we made reference to requiring them to be in the same specialty, etc. And addressing those areas that they specifically went through and eliminated from our regulations. And so we will repeal those sections. Now, when you're talking about competence, I need just to share with the stakeholders here that the reason that competence was not something that we asked them to do ever through that attestation, so that is not a change with the writing of this law. We, as a board, from when this was implemented a few years ago, never request the physician surgeon or the nurse practitioner to attest to competence because that is not their role. Competence is always and will be always determined by the employer, the place of hire. That is where competence is established. They establish how that is going to be measured in their policy and procedures, in their bylaws, in their onboarding, in their credentialing. That's where competence is established, and that is outside of our board and our ability. So competence will still be determined. What was additional to this section when AB 890 was written was to see if the national certification verified or vetted that these people had competence to perform independently. And that national certification, when OPES took a look at that, they determined, yes, it did. And so that is an additional layer in here that says they are minimally prepared to practice independently as verified by their national certifying exam. And the employers will continue to be the one that vet the competency as outlined in their policy and procedure. And so what occurred on implementation of that, again, this is not a change to our regulations on whether or not the attestation had anything to do with competence, is that there were a few groups that thought that they may, if they signed that the transition of practice was completed, that they may be held liable for any incompetence that occurred later on. And so they were hesitant to place that signature. Reza, our legal counsel, myself, we had several meetings with CMA and with CANP, and repeatedly said that you would not be liable for signing that the hours were completed, would not be held liable for competence. But I think there was still a big fear. And so that is why this language was added, not to change what we did, but to provide clarification. In fact, outlining specifically what Reza had stated, where you would not be held liable unless the attestation was produced fraudulently. And that was the only time that you would be held liable. So hopefully that helps to explain that this wasn't a law change. And in fact, it is in alignment with our regs, specifically talking to the attestation and competence. That competence is outside of our jurisdiction at the Board of Registered Nursing.
So you're still saying that the competency will come in as they're practicing in their 103 facility?
Any employer that they are employed at, whether as a 103 or as a traditional NP under standardized procedures, even as their RNs, all of them are comped by the employment area that they are in, not by BRN.
Okay. So what about, but the whole idea is to practice independently.
Correct.
So somebody's got to determine that they're able to practice independently. Suppose they don't have anybody that is having them as a mentor. They don't have mentorship. They don't have collaboration.
So they have to. So when we go down into the 103 section, the 103 section right here, I'm going to highlight, requires the nurse practitioner, once obtaining the 103, to work in these specific settings with one or more physicians and surgeons, and that is for an additional 3 years, right? So they've become a 103. They can only be employed in these specific areas. They cannot have their own practice. They cannot work for a nursing corporation. And in fact, they can only work for a medical corporation right here, including a medical corporation. You can see right here, not a nursing corporation. And so during that 3-year time period that they are working without standardized procedures, utilizing their 103 status, they must work with one or more physicians and surgeons. And in order for them to move through that section to become a 104 NP, which is that independent practitioner, which can work outside of these group settings, they have to have done that collaboration with the one or more physicians and surgeons working in those specific healthcare settings that are identified in law, and additionally shall not have any disciplinary action brought against their license at that point for any kind of errors or anything that occurred. So that therefore establishes an additional type per se that they are competent, as they haven't had anything detrimental to their license during that period.
Okay, so I'm going to ask a question just for my own clarification. So somebody, a physician has a fellowship in diabetes, and a nurse practitioner who works solely in the area of diabetes and goes through the 103, the collaboration with that physician who is not a primary care physician, then that nurse practitioner moves on appropriately to a 104. So we will be having that person can say, I'm a specialist in diabetes and I pending as a nurse practitioner.
No. So in
No.
the 104 section, I'm going to highlight this statement right here that says the 104, a nurse practitioner authorized to practice pursuant to this section shall comply with the following. And the very first sentence says, the nurse practitioner, consistent with applicable standards of care, shall not practice beyond the scope of their clinical and professional education and training, including specific areas of concentration, and shall only practice within the limits of their knowledge and experience and national certification. And then the very next one talks about they shall consult and collaborate with other healing art providers based on the condition of the patient. Physician consultation shall be obtained as specified in the individual protocols under the following circumstances, and it clarifies it here. And then it says the nurse practitioner consultation with a physician or surgeon alone shall not create the patient physician-patient relationships, and that they are still solely responsible for the services that they provide. It then talks about establishing a referral plan for complex medical cases and emergencies to a physician, a surgeon, or other appropriate healing art providers. So even when they move to the 104, they are held to the requirement that they have to practice consistent with their standards of care, the knowledge and experience of their national certification, and that they have consultation with physicians and surgeons and referrals for complex medical cases. So they are not alone independently. They still have services that they can reach out to for assistance if needed.
Thank you, Melby. That explains, that helps me. And I like that you explained it, and it's in the minutes for clarification for other people to look at as well, particularly physicians. Thank you.
You're welcome. Oh, looks like my session has expired. That means we've talked too long already. So I'll pull that back up, but I'll stop screen sharing at this moment.
Thanks, EO Melby.
And
Any
then
other
Marissa, if you had
comments?
more to share, you can at this point. I'm going to pull the bill back up.
It just, if there was any other questions on that, we're going to move on. Okay. So I will jump down a little bit and kind of out of order in the bill, just because it's staying on eligibility for the 103. Section 12 in the bill amended BPC 2837.105. And that has to do with the requirement that Lori spoke a little bit about around having the Office of Professional Examination Services look at those national certification exams. And as I'm sure you're familiar, because I know this has come up for discussion quite a few times, there was a bit of a hiccup because that language basically required OPES to look at, in determining competency, as Lori said, to look at the current, upfront, take a look at the current examination and then have kind of an ongoing review to make sure those competencies align. There was a issue there when it came to retired and legacy certification. So these are folks who were certified, probably have been practicing for a good amount of time, but just over time that certification had been retired and transitioned to something else. There was no longer an active examination that OPES could review to verify those competencies. So we got kind of stuck between a rock and a hard place where we had a lot of very seasoned practitioners not eligible to apply because OPES couldn't look at an existing examination as was required by that section. So to address this, what they did was they added an exemption that states this paragraph shall not apply to National Nurse Practitioner Certification examination that was discontinued before January 1, 2017. So that allows for us to provide or accept certifications that may have been retired legacy certifications that may not have an active exam because it would exempt that OPS review requirement from it. Any questions?
So that would be the entire, so they would skip through the 103 and go on to stay at 104, correct?
No, this would make them eligible for the 103 to begin with. So
okay.
Previously, yeah, and they, in determining kind of what categories, the law said OPS had to look at those national certification exams to make sure the competencies tested in those aligned with the competencies of what was being expected of a 103. So if they didn't have an active exam, our hands were kind of tied because there was nothing to review. So this doesn't kind of skip them over. It just allows them to enter that same eligibility kind of process that any other NP who's practiced for a while would.
Thank you.
All right. Are you done with that review, Marissa? Are you going to go over the other sections or?
One more section, if there weren't any other questions I can jump into. The last one has to do with notice to consumers. And so let me find the bill
I can bring it
section.
back up. Yeah.
So it's section 11, so it's right before the one I just spoke about. Under previous law, the law required, and we spoke a little bit about this in the previous item, the nurse practitioner was required to verbally inform all new patients in a language that's understandable to the patient that a nurse practitioner is not a physician and surgeon. And the law went on to specify that for Spanish language speakers, the nurse practitioner shall use the standardized phrase enferma especializada. The law made a couple changes to this. It removed verbally. So that can be, they can inform them in writing or verbally. It just removed that it had to be verbally. And it removed the uniform standardized phrase for Spanish speakers because there was a lot of feedback from the community that may not be the most accurate translation in a lot of instances. So while I think the attempt was to try and make kind of a standardized approach for clarity, I think what they were finding, it was leading to more confusion with patients. So they just struck that altogether and just left the requirement that NPs inform all new patients in a language that is understandable to them. So that provides them the flexibility. It doesn't specify an exact phrase that has to be used. And then it also added a provision, and this speaks to a requirement that's in our regulations, that states a nurse practitioner practicing under this section and not working under standardized procedures shall not be required by the board to tell a patient that the patient has a right to see a physician and surgeon. And that is something that we had in our regulations under 16 CCR 1487, a provision around advising patients they have a right to see a physician and surgeon in the circumstances. And this strikes that requirement and our ability to impose that requirement. So we will be removing that from our regulations.
So clarify that again, please.
The second part?
Yeah,
sure.
The language. So
in our regulations, this wasn't previously in the bill, there was a provision under 16 CCR 1487, the notice to consumers, and it was subsection C, and it states that and all NPs have to advise patients that they have the right to see a physician and surgeon on request and the circumstances, under which they must be referred to see a physician and surgeon. I think kind of piggybacking off that that provision that Lori just spoke to around kind of the referral plan being in place and having that, but it wasn't a requirement in the law. So the law actually added a provision prohibiting us from requiring that. So we are going to have to update our regs to remove the requirement that states NPs advise their patients that they have a right to see a physician and surgeon.
But if requested independently, they can.
Sorry, say that one more time.
So if the patient requests a physician, they can't, unless they're in a 104, there isn't going to be a physician involved.
Yeah, the patient can still, I think, always request. I think that's in the provision of when there's a referral if a patient requests it. I think it's just taking away the board's ability to impose a verbal notification by the NP upfront.
Okay. Thank you.
Any committee members with any comments or questions about this bill? I have kind of a comment and a question, actually. I don't know if either of you can answer this, EO Melby or Marissa. So under the 103 section, which is section 10 of this bill, subsection 3, paragraph C, I found this oddly specific, and I'm just wondering if you could provide some context. It basically says that a nurse practitioner shall not vote at department, division, or other meetings. And I think the context here is like within a hospital environment, where presumably these departments are under the leadership of a physician. I'm just curious, like, why they create such specific language. I thought this is something that would be much more regulated on the local level by a medical institution deciding who can vote at their various committees and things like that. Is there some kind of legal precedent for this?
So this was part of the original AB 890 and was not updated in this go around. I believe it was part of kind of the bargaining back and forth. So when they were going through the various language, CANP comes to the table, CMA comes to the table, CDPH comes to the table, and they're like, I want this, I want this, I don't want this, I don't want this, and they try to come to an agreement. And typically you will see very specific language that came out of those meetings. And sometimes they were a compromise to get other sections through, and maybe this one wasn't as high of a priority for CANP. Obviously not in those meetings. I can't speak to it 100%. I can just talk about how typical meetings go when we're talking about the legislative process, is where they bring the key stakeholders together and they have a lot of conversation. What can you agree to? What can you let go? What are you holding firm on? What will you oppose? And they do their best to remove any stated opposition as they move this through. But this was done as part of AB 890 and not necessarily updated here. So I can't state specifically where that language here comes from. Now, Jan, Kevin, Sally, if any of you guys were part of that or heard anything with CANP that could share on that, or if this has negatively affected you guys in any way, we'd love to hear about it.
It just seemed very specific, and I didn't realize the state of California like really reached that deeply into hospital administrations, decide who's voting on committees and things like that. But just kind of eye-opening to me.
When you have a free moment, if you want to read Title 22, you'll see how specifically in depth it goes to.
Well, yeah, it's specifically referenced here. I'm definitely going to do that, actually.
Yeah.
Right.
Title 22 is a very robust document. They go so far as into telling you what the size of the hospital room can be. They define the space around the bed, where you actually, if you have a bed in a room, you have to get down with a measuring tape and you have to measure out the space around that bed, and egress, everything on there. I mean, it gets very, very specific. And so if you've ever really wanted to know more about what happens in hospitals that follow Title 22, that's an amazing piece of work. I used to work in an area, we were opening a hospital, and I was one of those people on the floor with a tape measure, measuring out around the space around each one of the medical beds, because we brought in emergency supplies to make sure that it met Title 22. It was incredibly tedious, but absolutely important, just because you wanted to make sure emergency services and their equipment could get in, and not be limited or, knocking a provider out of the way. So they do get as detailed as that. Now, further discussion here today is really just kind of looking at a path forward as we look at this. The one thing that I think if we kind of approach this from a very kind of expeditious kind of way, I'm just trying to, how can we comply with this law quickly, is just to let everybody know that, again, kind of my speech today in both advisory committees is statutory language always supersedes regulation. So effective Jan 1, even though the language is in our regulations, the statutory language is going to supersede. So we have to abide by the law that is now current, and that's the updated language. So effectively, all of our regulatory language that conflicts will no longer be held to the letter of the law. That will be removed. Now, when we look at the regulatory process moving forward, there is a very simple way that can be done, and we can go through and line this up with our regulations and repeal the sections word for word that we can no longer have. What I think would be additional discussion is we do have our subcommittees that work on this regulation specifically for 101 section, another one for a 103 section, and another one for the 104 section. That was the breakdown of the 3 subcommittees. Those subcommittees could look at that language and say, with us pulling this language out as required in statute, is there any additional clarifying language that would need to be added to ensure that the statutory language can be brought fully implemented, right? Our regulations are the ability to implement statute if there are any areas that need clarification. And so what I would ask of our subcommittee is to go back and look at 101, go back and look at 103 and 104 in the regulations that were produced by it. And I'll show you where those live. Here, I'll screen share as well. And I'll actually walk you guys through the whole process so you guys can get to there. And so let me make this a little bit bigger for everybody. So if I'm going to start from scratch, I'm going to type in rn.ca.gov. And then I'm going to go to my Nurse Practice Act, which is right here at the middle of the page. And then I'm going to go down to Nurse Practitioners, which is Article 8 under the California Code of Regulations. And then we have the various areas that were affected. So in definitions in 1480, we defined group setting. I believe that can stay. That's still in accordance with our law. And that section was not updated. However, when we look at the categories here, we have the 103 defined here and the 104 defined here. And it references back to just these 6 categories. We will have to update here to include the retired and legacy categories. And those are specific prior to 2017. We'll pull those forward and that will be updated. So now our next section that will need to be looked at, and I'm just going to go documents in sequence here. That's not our certification. Sorry, I'll just move here. So this is our 103. This first section here where it talks about, you know, your name, your address, your email, those are pretty standard. But the one things that we do need to address are this attestation right here. And so we'll actually have to address 12 because right here it refers back to 1481A for the categories, and those categories are much more expansive. And then in 13 here, this is where it talks about the attestation. And it talks about the attestation saying that they must specialize in the same specialty area or category listed in 1481 in which the applicant seeks certification as a nurse practitioner pursuant to 103. And they must not have a familiar or financial relationship. So that will need to be updated. We could just strike those sections, but that might be where you would want to take a look at that to see if that's something that you still think holds true, or if there's any additional clarifying language that would be needed. And this here is the 104 section. There wasn't much changed in that 104 section except for having to identify yourself, but we had put that in a separate section. So let me buzz through this real quick. So 1483 was not updated. This one was not updated. Sorry, we're going through kind of our education requirements here. So let me get through those quickly. And I think it's coming up right here. 1487. So those were both repealed. So those no longer hold steer. And here's the one. And so as this loads, you will be able to see the language of what we need to put for the notice. And so all of this here stays the same. We will have to remove the term verbally, inform new patients. And so it'll just be inform new patients. We would then remove the section where it says for purposes of Spanish speaking language, remove that. And so basically it'll say, inform all new patients in a language understandable to the patient that the nurse practitioner is not a physician or surgeon. To me, that's pretty clear. You guys might want to look at that and think that there needs to be additional clarification. And then this section here will be repealed completely here. So again, as you guys take a look at them, look to see if there's any additional clarifying language that's needed once that information is pulled as compliant with the statutory language.
So, thank you for that, UMLB. So, so you think this is best done in the subcommittees, and how do we move forward with this? Is the board staff going to like outline the things that you just pointed out and contact subcommittees directly so that they can kind of make suggestions to the broader committee, or how do you want to approach that? Or how do you suggest we approach that?
I think we can do that. I think what we'll do is we'll have a standard email that'll go out to the various subcommittees, asking you guys to take a look at those sections to see if there's any changes as the subcommittees were already formed. If you guys need a refresh in who was in those subcommittees, I can let you know that Dr. Ray and Betha were in the transition of practice. And so that is the 2837.101. Kevin and Jan were in the 104 section. And the 101 section that pretty much carried over into the 103, right? And so now discipline is where Sally and Samantha are on. And so there is no specific section of 103, but again, I think the 103, there wasn't any real changes to 103. It was just the transition of practice to enter into 103. So I think Kevin and Jan can look at the 104 on that verbally informed patients and see if there's anything that you guys would think would need to be added to clarify. But most of the work is going to lay with Dr. Ray and Betha, and really looking at the 101 updates to that transition of practice and what that means. And if we are absolutely here for you. Marissa's here for you. I'm here for you. Our regulatory counsel with DCA, Stephen Bong, is here. We can all get on meetings with you guys as frequently as you want to kind of go through language if you think that there needs to be any updates other than just kind of lining out the provisions that were stricken to make this implementable. We do not have a delayed implementation date. And so that it is effective immediately. Is that correct, Marissa, on this? And so whatever we do not have for clarification would not be implemented Jan 1. We would have to go through the regulatory change process to get that done. So in the meantime, there would be a period of time that if there was clarification language needed, we would not have it.
So, and then presumably once we have those recommendations, that'll go to the committee, we'll take a vote, and then that goes to the board, to the BRN to adopt that regulatory language?
It does. And so if you guys had some substantive product to produce for your
I think we might have lost EOMLB.
Yeah.
Give her a second to see if she can reconnect here.
I can clarify that, yes, any proposed regulatory text does have to go to the full board for approval before we start the initial rulemaking process.
Okay, but as far as the timing of this is something that will come up at the March meeting, presumably. And if we need
So,
to,
yes.
if we need to have a broader discussion before then, we would have to set up another committee meeting. I'm not sure that's going to be necessary, but okay.
So if
Dr. Espinosa.
if we have any thing to contribute or discuss, do we go to the subcommittees or to Ms. Melby?
So it sounds like what she wants to do is open herself up to meeting with the subcommittees individually, since I guess, you know, based on regulatory language surrounding or statute surrounding, you know, public meetings, can't all convene unless it's a publicly announced meeting, but she can meet with each of us individually in our subcommittees to kind of clarify things and provide some guidance if you need it.
But if we have something to contribute before the March, people that
Yeah, I mean, I think the ask here is that each subcommittee just kind of come up with recommendations based on their section and whether or not they have those recommendations to change the regulatory language, which will then be presented to the committee and presumably to the board.
So the answer is no.
I'm sorry, maybe ask your question again. I don't know if I understood.
So the answer is no, that we won't be contributing until March.
I mean, the committee is not planning on meeting again before March, so, right.
So the answer is no. It's whatever who's on the subcommittees will be making those recommendations,
Correct,
and then we see them in March. Is that correct?
correct. And I mean, she essentially outlined for us, like, what are the areas that are kind of glaring that need to be addressed? And maybe there's going to be others that come up as well. All right. Any other comments from the committee before we open it up for public comment? All right, seeing none.
I think Jan's got her hand up.
Oh, sorry, Jan, I didn't see you there.
No, no problem. If Dr. Espinosa did have something that she felt she wanted to communicate to a subcommittee, is there any reason why she couldn't go through the executive director to do so?
I'm guessing not. I'm guessing as long as it comes from her, we can't convene a meeting of more than 2 people without, having a public discourse. And
No, I understand that part of
yeah,
it.
but I would guess that if you had a question and you ask Lori and say, hey, can you give us some guidance on this? Or this is something we think needs input from other subcommittees, I'm sure she could be the person to communicate that without violating those rules.
I would think so.
Thank you, Jan.
My second thing that I had wanted to say was, did I mishear her when she said that each of these subcommittees would have a nurse practitioner on it?
I believe that's correct. I don't think there's any subcommittees that do not, right?
That is correct. Sorry, I'm
yeah,
back
and-
on in
Hey.
via phone, if you guys can hear me. Resetting my computer here. So
Okay.
the current subcommittee we have right now is in 101, and right now it's Dr. Ray and Betha. So there is not a nurse practitioner on that one. The 104 is Jan and Kevin, both nurse practitioners, and discipline, Sally and Samantha, both nurse practitioners. So in order to get nurse practitioner feedback on the 101, you guys could consider redoing that setup. But honestly, there was no issues with it last time. And where you can get nurse practitioner feedback is by reaching out as that subcommittee to a nurse practitioner not on this advisory committee. So maybe the president of CANP or president-elect of CANP, and have conversation and input. And that's where the subcommittee is able to have as many of those meetings as needed. Then you can take that information in, use those subject matter experts, and then you bring it to this committee. On this committee, there are 4 of you guys that are nurse practitioners and could provide, or 5 of you guys, sorry, provide that feedback before it leaves this committee. So you will have the eye of a nurse practitioner on it at all points.
Thank you.
Thank you. Go ahead, Dr. Espinosa.
Yeah, I guess since we announced it to the public that all committees had nurse practitioners, and I thought it was, I would like to see a nurse practitioner in that committee that you're on, Dr.
Yeah, I thought the same thing. I thought that Sally was on my committee for some reason, but I think we might have shuffled the subcommittees at some point earlier. So
this is Jan Griffin, should we consider shuffling again then? So that we are doing what we said we were doing?
I mean, this specific item is not on the agenda, but Melby, is it possible to make a motion and vote on changing the subcommittees if we were to find enough people to do that?
We could change the subcommittee. I'm looking at the agenda right now. I'm trying to pull it up quickly to see if there is in agenda item coming up. If we have that ability to do that. And of course, as everything is rebooting on my end, I don't have
Yeah.
access
Agenda
to the agenda item.
Agenda item
Lori.
8 reads regarding discussion of the following subcommittees, including transition to practice and 104 and discipline. So
Yeah. We
it is
could vote
technically
then.
an agenda item. We could vote on it at that point if we had a motion, if that's sounds reasonable.
Yes, that actually can.
So when we get to the next agenda item, and if someone wants to make a motion to reformulate our subcommittee so that there is a nurse practitioner on each one, then we could open the floor to that. All right. Any other comments on this agenda item before we open it for public comment? Okay. And just speak up if I can't see you, because I can't see everybody raising their hands all at once. Okay. All right, then board moderator, if we could open this agenda item, open to public comment.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Charlotte Thomas would like to make a comment. 1 second, please.
And make a question. I know that a lot of the work around 103 and 104 was geared towards patients, nurse practitioners. However, I'm wondering thoughts of the board, or maybe something we discussed moving forward for those of us who work in hospital settings. I received a 103 license from the board, but none of the hospital systems that I am aware of are allowing nurse practitioners to actually practice without 103 or without standardized procedures, as that's part of their credentialing, and rightfully so. But I'm wondering, is that going to limit us to be able to apply for a 104 status if we haven't actually been by the medical staff? So I know that you don't always act on public, but just something to consider moving forward. How is 104 by those of us who are inpatient and haven't, technically been practicing with procedures? As I interpret it, it looks like we only have to have been one tied to whether or not we've been practicing without standardized procedures. But just something to consider, as I know that's a large population of us that aren't really sure how that's going to impact. And thank you for allowing me to speak.
I mean, that was kind of broken up, but I think the message that they're trying to get across is that if they can't get work as a 103, is that going to inhibit their ability to eventually become a 104 practitioner if there's no hospitals hiring 103s? Is that kind of the gist of what the commenter is trying to say?
That's what I understood.
I think there's nurse practitioners who in the hospitals that function as a 103, but they're still under standardized process, right? They're able to get the 103, but in order to get to the 104, you need to work without standardized process. So that's why it becomes a problem, is how then to these nurse practitioner then transition to 104 if they're still, once they get their 103, still continue to work under standardized process.
And so that is actually specific in our regulations. It does state that you have to have proof of practice as a nurse practitioner pursuant to section 2837-103 of the code in good standing for at least 3 full-time equivalent years or 4,600 hours in direct patient care. So when we look at this application process, we will have to verify that not only did you have the certification, but you utilize that. And in fact, that is working without standardized procedures in those specified group settings in order to move to a 104. That was something that was brought up. We are not able to have healthcare facilities utilize the 103. It is there as an option, but it is not a requirement. And if you are a nurse practitioner that wants to advance to a 104, you will have to look for a job at an employer that will utilize you in the 103 capacity to work in those group settings without standardized procedures, with at least one physician and surgeon there with you for those 3 years. There is no way around that in the law as it is currently written.
Thank you, Lori. Board moderator, do we have any other comments?
Sharon Vogan would like to make a comment. 1 second, please.
Hello, thank you, Sharon Vogan from Oakland. Just a comment. First, I wanted to thank Dr. Ray for providing the history of the scholarly definition of the term doctor. I was really happy that you just put that out there and said that it is an American problem. And I just hope that that will kind of help people step back and focus on the things that have a more direct impact on safety and the healthcare of our community, because there are so many issues to talk about. And I just want to make sure that, you know, too much time isn't wasted on the things that don't have a direct impact. And as far as I know, the assessment of competence for MDs is their education and training, and then taking the board exam. And that's what we're doing. So I just want to throw that out there. And then also just to clarify, there's independent practice, having your own clinic, and then there's practicing without standardized procedures, which you know, just are a little different from one another. And sometimes the term independent practice is used over both of those definitions. So I just wanted to point that out. And that also, independent practice doesn't mean that NPs will stop collaborating or consulting with providers with more experience, because we know that's our role and we understand our education and training. And our goal is to provide the best possible healthcare to our patients. And so if it means that we reach out to a physician or a specialist, including PAs and NPs who specialize in those areas, that's what we're going to do, because our focus is, you know, the best possible quality care for the patient. So I just don't want people thinking independent practice means I'm off in some, you know, small little clinic all by myself. Because good practice usually involves collaboration. Thank you.
Thank you for your comment. Committee Chair Ray, there are no other public requests for comments on the WebEx. We have no in-person representation in BRN HQ. Would you like me to close this window?
Yes, please close the window. And we can move on to agenda item 8. Melby, did you want to comment on this?
I definitely can. So this is the discussion and possible action regarding subcommittees. So we do have the 103, the 104, and the discipline. I know that discipline typically reports out during this section, but I also know that Sam is not able to attend. So I did want to touch bases with Sally and allow for you to do a report out. My understanding is that 101 and 104 has not met prior to this. So if Sally, if you have a report out for discipline that you would like to do, we can at this point before moving on to the discussion of the committee makeup.
Yeah, I was looking at the data and, it's kind of, I don't see anything this year in terms of discipline as an outliers. So it looks like some year there might be more, but overall it's kind of up and down, but not a whole lot in terms of the actual cases being disciplined. So I don't, so overall, I think we're not gonna have those real data until we truly see the 103 and then ultimately the 104 in practice. And like previously you said, a case could take up to 2 years before we actually see data.
Correct. Is there any discussion from the committee on this specific topic on discipline?
No, we didn't really discuss because I didn't see any trend to really, to go much more into depth with it.
Yeah, it is. It's pretty status quo at this particular moment. So just good information to keep out and share and have discussion or questions if there's any. Okay, so seeing no other discussion around this particular topic, this is where we would look at the current makeup of the subcommittees. And so again, I will share on discipline. It's Sally and Sam, and I think that you guys are good to continue there. On the 104, we have Kevin and Jan. Are you guys okay with staying within that setup?
Well, it seems to me that we should have a nurse practitioner on each one of the subcommittees. And so if I'm looking at this correctly, that means that Kevin and I should split up, and so should Dr. Ray and Ms. Betha.
Correct. So is there a suggestion from this committee, advisory committee, that you guys would like to see a change? Betha, would you be willing to transition to 104 in place of Kevin or Jan? Or Dr. Ray, would you be willing to transition to 104 in place of Kevin or Jan? And you guys can just kind of swap if that's something that you guys are interested in.
Yeah, I mean, I was just gonna say, I'll defer to whichever nurse practitioner wants to, take over that position on the committee. I'm happy to move, but.
I think I'm going to suggest that given my limited tenure, as I understand it, on this committee, perhaps it would make more sense for me to go to 101 than it would to stay on 104.
Okay, so Jan, you were willing to go to 101. Betha or Dr. Ray, are either of you guys willing to move to 104 and swap out with Jan, as we are only allowed to have 2 people in a subcommittee?
Yeah, I'm open to it.
I'm completely flexible for whatever works.
Okay. So from the committee, the way that the 101 can be formulated is with Dr. Ray and Jan, or Betha and Jan. Is there a preference with the committee on how that is formed? And if so, please let it be known.
I mean, just to put it out there, and I'm very flexible, but the 101 and 103 are kind of lumped together, right? It's a transition to practice, and it's kind of I think it's a big chunk of what this committee is doing, the subcommittee and the committee as a whole is doing. So I guess what the question is, is having the input of an MD in addition to a nurse practitioner helpful or not helpful to that discussion? So that might be really kind of what we're thinking about or voting on, as opposed to also having someone who's at large. Go ahead.
I'm feeling that an MD would be important on the 101/103. No disrespect, of course, to Betha.
Okay. So the proposal would be that it would be Dr. Ray and Jan on the transition to practice, and Kevin and Betha on the 104. Is that, did I hear that and capture that correctly? Okay, if you guys are in agreement with that, we would need a motion and a second.
I'll make a motion to accept the changes to the subcommittees as outlined. It's
Okay.
Kevin Maxwell.
Yeah, this is Sally. I will second that.
Okay.
All right.
at
So we
this
have a
point-
motion and a second, and just to clarify the motion, it's to reconstitute 2 of our subcommittees. So the 101, 103 transition to practice subcommittee would consist of myself, Dr. Ray, and Jan Griffin, and the other subcommittee that is being altered is the 104 subcommittee, which would become Dr. Kevin Maxwell, nurse practitioner, and Betha Schnell.
Correct.
So before we can vote, we have to open it up for public comment. So board moderator, if you could do so.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. Whoops, hold on here. Oh, there you go. I've activated the question and answer feature.
As I'm going to let you open that up, and then I was noticed that Dr. Espinosa had a question, so I'm going to answer that while you open up public comment.
Okay, I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing in the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comment. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in they would like to make a comment.
And so it was brought to my attention that when I dropped off and had to restart my computer, that Dr. Espinosa asked how she could make any kind of input prior to the March report out on subcommittees. At that point, Dr. Espinosa, if you have comments, just go ahead and email them out to Macaulay and myself, and we will have that information as we move forward, so that way your voice can be heard.
Thank you.
Thank you.
Thank you. Committee Chair Ray, there are no public requests for comments on the WebEx. We have no in-person public requests for comments in BRN HQ. Would you like us to close this window?
Yes, thank you, moderator. And I apologize if I kind of cut off the comments there among the committee. Was there anyone else who had something to add to agenda item 8? Dr. Espinosa?
Just to clarify on the motion, that it includes the change is predominantly to include a nurse practitioner in each committee. And I think it's important to include that in the motion, why we're doing that.
So you can preface it with the statement in the interest of ensuring that a nurse practitioner is involved in each subcommittee.
Exactly. And
then the rest of the motion.
The change.
I think that's reasonable. Okay, so we have a motion that was seconded, and we're going to vote on it now. Let's do our roll call vote. Samantha Gamble-Sfar is not present. Edward Ray, that is me, and I vote yes. Dr. Andrea Espinosa?
Yes.
Jan Johnson Griffin?
Yes.
Dr. Kevin Maxwell?
Yes.
Sally Pham?
Yes.
And Betha Schnell?
Yes.
Okay, so the motion is universally accepted by all present. So we'll move on to the next agenda item.
Thank you. So agenda item 9.0. The reason that we wanted to bring this forward and give a quick little update is we are under the impression that nurse practitioners and such that are operating in a med spa or IV hydration may not know that they are operating outside of their scope of practice. And so we wanted to make sure that we provided this information here and had a fairly quick discussion, as we are getting more and more complaints brought in front of us, either by a person who has received harm from this clinic or by another outside investigator. A lot of these hydration clinics are maybe within a naturopathic's office or a chiropractor's office. They may be in a barbering and cosmetology esthetician type office as well. They're kind of popping up everywhere. And so some of the big things that we want to make sure that they're aware of is, in light of the 103 and 104, is typically this is not part of the defined group settings that are outlined in that was outlined in AB 890 on what those specific group settings were. And a lot of these IV hydrations are set up as a nursing corporation, and those were also not included in the 103 section, and there are no nurse practitioners currently operating in the state of California as a 104. So there is not at this point an independent practitioner as a licensed nurse practitioner in our state. There are independent practitioners out of state, as we are all aware of, but not within California. And so if you are a provider and you are providing independent services in your med spa or IV hydration clinic, please note that that is not in alignment with the law. And if we do receive complaints, we will have to do an investigation. And based on that investigation, if evidence comes out, that there will be discipline on the licensee for practicing outside of their scope. One of the other things to touch base on is physician supervision at this point in those clinics, because even a nurse practitioner that's operating under standardized procedures, which is the way that a person would have to work in this area right now, because we do not have an independent practice available at this point, does have to have a physician that is part of those standardized procedures that are giving them that ability to operate in that manner. There are exams that have to be done in order to establish the patient and in order to create a plan. Some of the procedures that we have come across have been very broad, to say the least, and do not follow what you would expect to see in a standardized procedure. In our regulations, we have a specific section that calls out the standardized procedure, and I think I'm just screen sharing most of the day today. So I'll pull that up and screen share real quick so you guys have an ability to see that. And so when you have a standardized procedure, you would look here under the California Code of Regulations, Standardized Procedure Guidelines. And right here is 1474. And in 1474, it defines the 11 specific areas that must be addressed. And it says each standardized procedure shall be in writing, date, and signed by the organized healthcare system, personnel authorized to approve it. Specify which standard procedure function the RN, and in this case as well, the nurse practitioner, may perform and under what circumstances. State any specific requirements which are to be followed by an RN or a nurse practitioner in performing particular standardized procedure functions. Specify any experience, training, and/or education requirements for performance of standardized procedure functions. Establish a method for initial and continuing evaluation of the competence of those RNs and nurse practitioners authorized to perform standardized procedure functions. Provide a method for maintaining a written record of those persons authorized to perform them. Specify the scope of supervision. For example, is it immediate supervision by a physician? Set forth any specialized circumstances under which the RN is immediately to communicate with the patient's physician concerning the patient's condition. State the limitations on setting, if any, in which the standardized procedure function may be performed. Specify patient record keeping requirements, and provide a method for periodic review of the standardized procedure itself. The reason this is incredibly important is one of those says state the limits of the setting that this is provided. We know that IV hydration services are happening in party buses, in people's homes, at centers. And if those are not part of the healthcare facility's license, those cannot be done in those settings. So it is important to look at your license and what areas are covered within that license. They could be. I mean, you can definitely provide services in a hotel or at a home health care visit or at a palliative care center. You know, those are various areas of your healthcare license, but it has to be specifically outlined to include those other areas. You can't just go out and perform services in those areas because you want to. The other thing that becomes problematic, which is a huge issue, is where the pharmacy law comes up, and that is compounding. And so really, really quick for everybody on this call, and please share it out with your friends and family that are nurse practitioners or RNs that are providing these services, is that in our law, in our statute, it is specifically forbidden that any RN can compound. It actually says they cannot compound. Compounding of medications are mixing medications outside of their labeled use. So can you add a diluent to the antibiotic? Yes, absolutely, because that is on the label and it specifies what it is. Another example that you cannot do is have a bag of normal saline and inject B vitamins into it and inject Zofran and inject anything else that you might be told to inject. That is compounding. And if you are doing that, it is illegal. It is against your scope of practice. And those must be done in a compounding pharmacy, and it must be patient specific. And that is something that I don't believe our RNs, our nurse practitioners, are aware of that. There is a caveat for those that are in healthcare settings, like in your operating room, where it says in the pharmacy law, it says that you can compound up to 3 sterile medications, one of them being your IV fluid, in a case of an emergency. The pharmacy law defines the emergency setting as it must be life or limb sparing, and it must be administered within a specific time period. Now, any IV hydration clinic, any med spa clinic, there should not be any emergency life or limb sparing procedures happening. In fact, your policies and procedures would specifically state that if an incident occurred, that you are to initiate emergency transfer and services in that manner, and that you are not to start doing that. So there should be 0 compounding happening in these IV hydration clinics. That compounded medication, which would be your banana bag or your IV bag with the various additives, must come from a compounding pharmacy and must be patient specific. And so one of those issues that we're finding, unless it's a standardized compound, is that if you show up day one, you've not been established as a patient, you see a provider, and that provider orders this IV hydration, and they go into the back and they inject the different things into the IV bag and hang it, they violated the law. And they are in fact compounding, and they cannot do that. And so we are really working diligently to get the message out that what we used to be able to do in times past as an RN, and I'm guilty of that, 20 plus years ago, is you could. I used to hang bags at the hospital where we'd have a delivery, whatever, and you inject your Pitocin, you inject whatever you needed into that bag, and you did it right there at the bedside, you move forward. You cannot do that now. The updated pharmacy laws does not allow that. So what we used to be able to do is not allowed currently. So please reach out to us, ask for scope of practice questions, go back to our laws, really look at our law on what is allowable and what is not. Understand specifically the difference of what it means to reconstitute a medication versus compounding a medication, and understand that compounding a medication is explicitly forbidden in our law, and it cannot even be construed. And so Business Professions Code 2725.1, and I will do another quick screen share. Thank you, board moderators, for staying on top of this today with me. And so 2725.1 says right here that no registered nurse shall compound drugs. And it is one simple sentence right here and explicitly covers that. Understand that all of our advanced practice RNs are nurse practitioners, nurse midwives, clinical nurse specialists, certified registered nurse anesthetist, are licensed as RNs and have an additional certification on top of that license. So they are all held to this standard, even if they are a nurse practitioner, nurse midwife, clinical nurse specialist, or CRNA. It doesn't change that scope of practice. And so it does say no RN shall compound drugs. And so I wanted to make sure that that was very clear and out here, because I would rather re-educate or initially educate our practitioners so that they can immediately cease practice where they are violating their scope of practice versus having us to come out, do investigations, and be punitive in nature. I would love to preempt any of this discussion. And in that manner, we are working on some educational literature, some social media outreach, so that we can get that out to everybody.
Melby, thank you.
Questions?
That was really, really informative. I have a quick comment and a question. Is the BRN, how are they monitoring this type of violation of scope of practice? Are they waiting for complaints to come in, or do they actively seek out suspicious looking establishments and try to crack down on this type of thing?
So what is currently happening is we are getting it on complaint based right now. We are looking in to see if we have the resources to go out there and do kind of spot checks and such. But right now it is complaint basis, and a lot of the information that we're getting is from other healing art boards, where barbering and cosmetology will go out and do an investigation on one of their licensees and see that an RN is also in their clinic. Or a naturopathic doctor, they'll have a complaint against them. Their board or bureau will go out there and look at them, and they'll see that an RN is also providing services in that clinic. Same with chiropractic, et cetera. And so we do get information via that modality, but we also get it complaint based directly to us. But the issue is the public is not aware that it's not allowed, because starting an IV and hanging an IV is within your scope of practice as an RN. It's initiating that, ordering that, and how do you make that, right? That becomes problematic. And so the public is not aware that the law is being violated. The RN, the nurse practitioner, is not aware that the law is being violated. So once this attention is drawn more to this matter, and we are starting to get more complaints or doing more investigations or spot checks, what we don't want to see is a lot of discipline. We would like people to alter and course correct now based on education versus having us to do any violation against their scope of practice and their license.
Any other comments? I don't see any hands up. All right, well, in that case, I guess we can open it up to public comment. Board moderator, can we do so?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Committee Chair Ray, there are no public requests for comments on the WebEx. We have no in-person representation in BRNHQ. Would you like me to close this window?
Yeah, let's close the window. Thank you. All right, on to agenda item number 10.
We made it, the final agenda item.
Yeah, we still got an hour left. We don't have to
We
use
do.
up the whole hour, right?
I don't think that we will. I will preface this that this same exact language was presented to our nurse midwifery advisory committee today, and they passed it without edit. And so we do have one sign off, and so we're hoping to get your sign off as well. So previously, this section in the disciplinary guidelines was brought up, and you guys passed some language with some feedback on it. It did go to the board, and the board accepted it, provided some feedback on it, and we started our regulatory process. When we, and I say we as in the greater we, not me, Marissa Clark and such, met with our regulatory counsel, there was some concern that was brought up about that language, as the language that we had presented was not specific enough. And in fact, we would have to further define a lot of additional terms and language and really kind of go into process that would potentially make it overly prescriptive and not necessarily implementable. And so we scratched it and we're starting all over. And so what we did is we took a look at other healing arts boards, looked at other disciplinary guideline updates that the Office of Administrative Law had recently approved. And so we took that language, reviewed it, and said, can this be something that BRN could feasibly implement and that would serve the purpose of public protection, et cetera. And our staff reviewed it, I reviewed it, and we believe that it's something that we can move forward with. At this point, board moderator, if you can also elevate Stephen Vong if he's on, and Shannon Johnson if she's on, to answer questions if needed by our committee. And so in our disciplinary guidelines, it starts on page 29, and this is just a snippet of our disciplinary guidelines. We're only updating one section. Where it says number 8, supervision, A, B, C, D, that is not up for discussion here. And in fact, it is not changing, and it is currently law as written. It's just because it had to be on this page because it is part of the section that we're updating. Section 8, A through D, is what is utilized for our standard RN or our nurse practitioner working under standardized procedures, our clinical nurse specialists, et cetera, because those require supervision and are not independent practitioners. When we look at E, and that is the bold text, that is the updated language. That is the language that we're asking you guys to take a look at, that we looked at other regulatory packages that had been recently approved by the Office of Administrative Law that specifically addressed independent practitioner supervision when a person is on probation and how that is managed by the board. And so this here is inclusive of our nurse practitioners, our nurse midwives, our clinical nurse specialist when and if they obtain independent practice, our nurse anesthetist as well. So anybody that has an independent practice could utilize these guidelines. It is not nurse practitioner specific. And so please review them. Our board enforcement staff reviewed them. We're okay with them. I reviewed them. I'm okay with them. Nurse midwife committee reviewed them. They're okay with them. So we're asking for an additional look at by you guys to see if there's anything that you guys see that stands out that need to be changed. And if not, we would ask for you to make a motion to move this to the board so that our board can take a look at it and consider it.
All right, I guess the question is, if we're going to take action on this today, did the committee members have enough time to read this? And if you haven't already read this, it's about a full page worth. You're talking about section E, right?
It is, yes. And so what this changes is if you're an independent practitioner and you're working without standardized procedures and you're in an independent practice setting, that setting is not defined. That could be, you know, as you're on call at a hospital, as you're seeing patients in a hospital. It could also be in your own clinic. And it requires that you, as the disciplined nurse practitioner, not practice at all until you have this supervision set up. And that we expect that once you get your decision in order, which is the court order document, and that's nothing that we can alter, that you guys arrange for the supervision as outlined in that decision in order court document. So if that decision in order says that you need to have in-person supervision, you would have to get a nurse practitioner or higher scope of practice practitioner, so a physician surgeon, to oversee you the entire time that you are providing direct patient care. Or if the decision in order says no, you do not require the physical presence, that a supervisor is provided, but it's just an occasional random check, that you would provide the supervisor that would be able to do this. This is very closely aligned with what physicians and surgeons do. It is very closely aligned with what dental does as well, to allow for you guys to continue to have your own business and your own privileging. We don't want to hinder that. And so you guys give us the supervision. We review it, make sure that it meets all the requirements. Some of that requirement is that that supervisor not have any prior discipline, that supervisor be licensed in California for 5 years and trained in the same specialty or content area as the respondent. That the supervisor shall have full and random access to your patient records, to evaluate all aspects of the practice, regardless of the areas of deficiency. And so those are some requirements here. That we want you to be able to practice. And so as soon as you guys can get this done, you bring that to us and we get this approved. And it says that you also must notify us within 72 hours of any supervision changes, and that it doesn't have like a business, close personal and familial relationship involved into, so that there's not any kind of conflict. And so that's kind of it in a nutshell. It seems on face value to me that it's fairly easy to implement, but I can have rose-colored glasses on. So I do want to have some feedback from you guys.
Yeah, I mean, it seems pretty straightforward, but before we entertain any motions, some comments, I think Dr. Maxwell has his hands up. Go ahead.
I reviewed this and I didn't see anything that bothered me. And I also like the fact that you said this is consistent across multiple disciplines. And I think for consistency's sake and for equity, I think it's important to keep it as close as possible to all the others without something special, you know, for nurse practitioners.
Agree.
Comments, Dr. Espinosa?
Yeah, and I'm assuming that they will pay for their own, if they do have to, or they have to get their own supervisor, correct?
Does the very last sentence says all costs of the supervision shall be borne by the respondent.
Oh,
The
I'm
respondent
sorry.
is the nurse
Didn't see that.
practitioner that is within our probation system.
Any other comments or questions?
Jan Griffin here. Is there a list of supervisors that is maintained by the BRN? Didn't think so.
There's no list of supervisors maintained by the BRN1 because we've never required that before, because there hasn't been independent practice. And so this is being immediately brought up right here. I am sure as we gain that information, we would have that, we could potentially share it out. But really, it's going to be specific to your practice, right? And so you would reach out to you would reach out to your coworkers. If you're part of a hospital, you would maybe reach out to the chief of staff, the CNO, see if they would know anything. And we do know that there are companies out there, all you have to do is Google, that offer up their services for this also, because you guys are not the first persons needing to do this. This is independent practices occurred in multiple other states, and they have those services provided to them in multiple other states. So it is a Google process as well. Not that I'm recommending anything in particular or that particular route, but it's not a new thing, even though it's a new thing to us.
Okay, and this is pretty consistent across states. I understand it's consistent across professions here in
Yes,
California. Okay.
Yes.
All right, thank you. No objections to anything. Thank you.
Thanks, Jen. Any other comments or questions? Okay, seeing none, we'll entertain a motion to accept this language and to endorse it. If anybody wants to make a motion.
We have somebody making a motion in a second.
As a committee chair, can I make a motion?
I can make the motion if you'd like.
All right, Dr. Maxwell.
Yeah, I'll make the motion to accept the language as written.
All right, do we have a second?
I'll be happy to second that, Jan Griffin.
All right, Jan, thank you. And before we can take it to a vote, we'll have to open up to public discussion. So unless there's any other comments at this point, we'll have the moderator go ahead and do that.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Sharon Bogan would like to make a comment. 1 second, please.
Hello again, this is Sharon Vogan from Oakland. I just had a question because you just said that you've never done this before, but I'm somebody who looks for preceptors for our nurse practitioner program, and I've seen for both MDs and NPs, who are on probation, that the terms of their probation is that they work with a mentor, and that they have to report it to the clinic that they're working at, and they have to check in, they have regular check-ins or regular check-ins with their mentor. And that sounds like what this was, but maybe I'm misunderstanding. So that's my question. I thought we already had this in place because I've seen it before.
We have it in place for the non-independent practitioner. We have that in place for your RN or your nurse practitioner working under standardized procedures. And as you can see with the nurse practitioner under standardized procedures, they're not independently practicing in their clinic. They have clearly defined in that standardized procedure who the supervising physician is, what their role is, et cetera. And so if we're in a probationary setting, there is a decision in order that's done that is given to our nursing education consultant that it works within enforcement. And we get a org charts, we get job descriptions, and we get duty statements, et cetera. And then we review those. And the nursing education consultant would reach out directly to that employer and get that approved, with establishing multiple worksite monitors to cover that person for the entire shift if it's maximum, half a shift if it's moderate, and a twice a day check-in if it's minimal.
I see.
And you're in a setting that can facilitate that. When you're an independent practitioner, you don't necessarily have that established, and so you will have to call in somebody that will have to be there to do a one-on-one and watch you while you work, or somebody that will do spot checks and review your records, et cetera. And so this particular independent practice supervision, we've never done. We have absolutely done worksite monitors with our RNs and other advanced practice RNs that do not have an independent clinic. Got it. If they had an independent clinic and were not able to have supervision at that point, they would have to stop. They would have to close practice temporarily until they're finished with probation. And that's not something that we want to see occur here. So we want to establish a pathway that allows you to continue to work in your independent setting with supervision that protects the public.
Got it. Okay, thank you.
You're welcome.
Thank you for your comment. Committee Chair Ray, there are no other public requests for comments on the WebEx. We have no in-person representation in BRNHQ. Would you like me to close this window?
Yes, thank you, moderator. Okay, I think we're ready for a roll call vote on this motion to set the language as written. Samantha Gambles-Farr is not present. Edward Ray, I vote yes. Andrea Espinosa,
Yes.
Jane Griffin,
Yes.
Kevin Maxwell,
Yes.
Sally Pham,
Yes.
and Betha Schnell.
Yes.
All right, this motion passes. And that was our last agenda item. So we are just about ready to adjourn. Any parting comments, EO Melby or anyone else?
No, we made it 40 minutes to spare. Thank you, guys. So Dr. Ray, at this moment, you can adjourn the meeting.
All right, we stand adjourned. I hope everyone has a wonderful rest of your week.
Thank
And we
you.
look forward to seeing you again in March.
In
Thank
March.
you.
Thank you, guys. Bye-bye.